Good morning, everyone, and thank you for joining us for the Medical Board of California's Panel B meeting. Pursuant to the provisions of Governor Gavin Newsom's Executive Order N29-20, dated March 17th, 2020, this meeting is being conducted via WebEx. Dr. Thorpe, you can go ahead and start the meeting.
Thank you, Sean. Good morning, everyone. Thanks for your attendance for Panel B. We have a fair agenda this morning, and we have a little bit complicated schedule going back and forth between open and closed session. We'll try to guide you through that so that we can do it without too much difficulty. Ms. Richards, would you read the roll call, please?
Dr. Gonadev?
Here.
Ms. Richards, you're muted again.
Just 1 second here, sir.
Oh, thanks. Okay. Dr. Mahmood? Ms. Lawson?
Here.
Ms. Campoverde?
Here.
Mr. Brooks?
Here.
Dr. Thorpe?
Here.
We have a quorum.
Let the record show that I'm here as well.
We wouldn't want to forget Dr. Krause. That would be unfortunate. And we would like to welcome Mr. Brooks as a new panel member today and a new member of the board. We're glad to have you here, Mr. Brooks. And we will go ahead and get started with the open portion of the meeting today. I'd like to turn it over to Administrative Law Judge to proceed with the hearing.
Good morning. Thank you, Dr. Thorpe. Do we have counsel for Dr. Yassa and a Deputy Attorney General present?
You can go ahead and bring those in. I see Mr. Zimmerman. Mr. Zimmerman, you should be able to open your mic now.
Yes, can you hear me?
Yes, we can.
Great.
From the district or from the Department of Justice, I have Steve Muni. I have down here at Jansen Tam, but I don't see that person connected at the moment. Steve Muni, are you there?
Can you hear me?
Yes, we can.
Oh, good. I am appearing for Mr. Tan.
Okay. And Mr. Zimmerman, I know an invite was also sent to your client.
I'm sorry, could you repeat that?
Invitation was also sent to your client. Should I be expecting to see your client?
Yes, thank you. My client, Dr. Yassa, is here present in my office.
Oh, great. Okay. Then I believe Judge Rowan, that would be all the parties we're expecting.
Okay. Thank you, Sean. I appreciate it. All right. Ms. Leitz, can we go on the record, please?
Okay.
We are on the record before the Medical Board of California in the matter of the accusation against Nadine Helmy Yassa, Medical Board number 02-2013-231-688, OAH number 2016-030977. This is the date, time, and place set for hearing in the notice of hearing for oral argument. My name is Heather Rowan. I'm an administrative law judge. I've been assigned to preside over this hearing. Prior to going on the record this morning, there was a quorum established. I may take the appearance of counsel, starting with counsel for complainant, please.
Good morning, Your Honor. Good morning, members of the board. For some reason, my video doesn't seem to be working. My name is Stephen Muni. I am a supervising Deputy Attorney General for the Health Quality Enforcement Section, and I will be appearing on behalf of the board.
Thank you, Mr. Muni. And for respondent.
Yes, my name is Bob Zimmerman. I'm appearing for Dr. Yassa, who is here in my office attending with me.
Thank you, Mr. Zimmerman. This matter has been remanded to the board from the Superior Court of California, County of Sacramento, with this instruction to assess the penalty in light of the court's findings. The following process and time limitations will apply. Respondent will have 15 minutes to make an opening argument. The Deputy Attorney General will have 15 minutes to respond, and I will give each 5 minutes for rebuttal and close. These time limits will be enforced. I will give you a 1-minute warning prior to the end of your time. Once I tell you your time is up, please conclude. At the end of the oral arguments, I will give Dr. Yassa an opportunity to address the panel if she so chooses. There is not a statutory or a policy timeline for that, but I usually give 5 minutes for that address. These arguments shall only be based on the existing record and shall not exceed the scope of the record of admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments and may not ask questions to elicit new evidence. After oral argument, the board will go into closed section to deliberate. The parties will not receive a decision today, but will be receiving it sometime in the future. I did skip over the part that the panel may ask questions of either the attorneys or Dr. Yassa prior to closing this morning. Anything we need to address before we move into argument, Mr. Zimmerman or Mr. Muni?
I don't believe so.
Not from me, Your Honor.
All right, Mr. Muni, and it looks like your camera is working now.
Yep.
So we'll start with respondents. Respondents, 15 minutes, starting now. Whenever you're ready, Mr. Zimmerman.
Thank you. First of all, I'd like to explain to everyone why we're here and the process that has brought us here. We took a writ from the previous decision, and that writ was heard by the 3rd District Court of Appeal. And the writ was granted by the Court of Appeal following their review, was granted in significant part and denied in part. And we've now been remanded back to the medical board with regard to compliance with the Court of Appeal findings and hopefully to reconsider the penalty at this point in time. The decision was rendered in February of 2018. Dr. Yassa has been on probation for approximately 3.5 years. The Court of Appeal, as you may know, is charged with reviewing the findings and the decision by presuming that there is substantial evidence to support the findings of the decision. In other words, there is a presumption when the matter is presented to the Court of Appeals that the findings were indeed supported by the record. What happened on our review by the Court of Appeal is that numerous findings of extreme departure or gross negligence were overturned, and despite the presumption, found to be unsupported by the evidence. In addition to that, there were numerous findings of simple negligence that were found to be unsupported by the record. That's what brings us to this part of the process. And let me tell you now a little bit about Dr. Yassa. She is a board certified in neurology. She has special qualifications in child neurology. She is also board certified in sleep disorders. She's been in private practice in the Sacramento area since 1995. Approximately 30 to 40% of her practice is seeing pediatrics. 2 of these patients were peds. Since the board's decision some 3.5 years ago, she has undergone additional training. And if I could read so that I don't miss this. She was awarded 23 Category 1 CME credits toward the AMA Physicians Recognition Award in the area of practical medical ethics and professionalism.
I'm sorry, Your Honor, I object to this. This is outside the scope of the record. This counsel's bringing in mitigation evidence that occurred after the board's decision. That's outside the scope of the record.
Mr. Zimmerman, this is not evidence that was before either the court or the administrative law judge at hearing. I realize that you're bringing in evidence because the court asked you to ask the board to specifically look at the penalty imposed. For the limited purpose of the appropriate penalty, I'll hear mitigation, some mitigation because that was the direction of the Superior Court. However, I think that reading it into the record is a little much. So if you could give us an overview of why you believe the penalty should be any different than what it was based on what the Superior Court found, then I will take that.
I'll do that. Thank you. So she successfully completed the PACE program. She has successfully completed record keeping and ethics courses. She has completed in the past 3 years 1,000 credits of continuing medical education. It's extraordinary. She has altered her practice in terms of cutting back patient loads and hours. All of this reflects her dedication to bettering herself as a physician and providing appropriate patient care. And I present that, as you recognize, Your Honor, in mitigation and in consideration of further penalty. It's going to be our request that, for lack of a better term, time served be recognized, and that there be no further probation, given the fact that she's gone through 3 years and 3 months of probation. The Court of Appeals, and I'm not going to go through each and every individual patient, but an overview I think is appropriate. And a couple of things that I think are mitigating factors I think are important. There is a young patient, BA. The Court of Appeals disagreed with the findings of the underlying decision and found expressly that her testing her testing was indeed medically indicated. They found that, contrary to the decision, the prescription of Prozac was appropriate and medically indicated. They found that the diagnosis of circadian sleep disorder was appropriate and disagreed with the findings of the underlying decision. What I wanted to point out was the treatment by a subsequent neurologist was similar to Dr. Yassa, yet it incorporated testing, which was many times that ordered by Dr. Yassa. The decision seemed to ignore that. The other thing I needed to point out in terms of exculpatory conduct was that Dr. Yassa followed the patient for 1.5 years with additional testing on her at her own expense. In other words, the patient changed insurance. Dr. Yassa was not being compensated, yet attempting to pursue the best interests of her patient, ordered testing that she was not being compensated for. And I think that the board needs to know that and recognize that. There was another patient. She was a 56-year-old woman who came in with, all experts agreed, the diagnosis of a demyelinating disease. The most common diagnosis for demyelinating disease is MS. And what Dr. Yassa did was, I think, extraordinary in an attempt to get to the bottom of what the proper diagnosis would be. This happened in 2012. She sought out an MRI that had been taken 5 years before. She had to contact various imaging centers to find that MRI. She was able to locate it, and she had it for a comparison with the MRIs that she ordered. She had a neuroradiologist specifically compare the MRIs. The MRI, indeed, the comparison was suggestive of MS. The Court of Appeal specifically disagreed with the decision, which found extreme departures with regard to ordering EEGs for this patient. The Court of Appeals found that the decision was unfounded with regard to their finding that of gross negligence in failure to consider other medications. In other words, this was a patient who had gone off of all medications at the time she saw Dr. Yassa. Despite that, the decision found that she was grossly negligent for failure to consider other medications. We were able to point out to the Court of Appeals that there were no other medications at the time that the patient was being seen by Dr. Yassa. The Court of Appeals found that the finding of extreme departure for the failure to diagnose Lermite's syndrome was unfounded based upon the evidence presented to the to the ALJ. I wanted to point out that a couple of things, and I'll conclude my comments. The hearing and the decision found every issue of fact and credibility on these 4 patients. And I point this out in my written argument, but I wanted to make sure it was clear why we were attempting to make this point. Every issue of fact, and there were dozens. I'll give you an example. Dr. Yassa documents at the time in question that there was a staring spell by this young girl during her examination. She documents it at the time it occurs. 7 years later, the mother testifies in the hearing and says, no, that never happened. There was not a staring spell.
Mr. Zimmerman,
Yes,
one minute.
of course.
Oh, I'm sorry. You have 1 minute to go.
I'm sorry, thank you. I got it.
I'm sorry I wasn't clear. Go ahead.
Sure. I just wanted to point out that it's an example of how each and every fact was decided against Dr. Yassa. Every issue of credibility, and there were dozens, was decided against Dr. Yassa. I point that out only to suggest that it reflects a certain bias, and I question the fairness of the impartiality of these findings. I'll conclude with this. Dr. Yassa is dedicated to providing her patients with the best possible care. She has shown this dedication through her commitment to education and the changes she has implemented in her practice. She has shown that past errors will not recur. Thank you.
Thank you, Mr. Zimmerman. And I'm sorry I was not clear about the 1 minute timer.
It's okay.
I gave you an extra 5 seconds to compensate for that confusion.
Thank you.
And I didn't want to interrupt you, but if there are parties on the line who are not actively participating or speaking, please mute yourselves while others are speaking so we can cut down on background noise. Mr. Muni?
Thank you, Your Honor.
15 minutes.
Thank you. Ladies and gentlemen, members of the panel, this written and oral argument shall be limited to evidence contained in the record, and no new evidence may be submitted. That's the medical board's own order, and I will comply with that. So let's talk about what the Court of Appeal left in this decision. Well, probably the best way is to go down by patient. So let's look at the first patient. That would be someone Mr. Zimmerman didn't mention. That would be patient. The first patient, patient RA.
Mr. Muni?
Excuse me, patient. Yeah.
Mr. Muni,
VA.
I'm terribly sorry. I'm going to stop the timer momentarily. I got a note saying that the court reporter was knocked off the call.
Ah.
I'm really sorry. These hearings have their own set of issues, but
This is a court reporter. I don't think I got knocked off.
okay.
Can you hear me? You can hear me and see me?
Yeah, I'm terribly sorry. I just got a message that popped up. I will We'll keep going. This, I'm terribly sorry. The whatever just happened, I'm not sure, but we'll pick up at 14 minutes with Mr. Muni and Ms. Leeds. As long as we're still on the record, we'll go. And not sure what happened. Mr. Muni, 14 minutes.
Thank you. Thank you. All right. The purpose of this hearing is to determine the appropriate level of discipline, not to punish the doctor, but to protect public safety, number one, and to allow for the rehabilitation of the doctor. So let's look and see what the appellate court left in. Patient VA, they left in everything, all the counts of gross negligence, all the underlying issues of record keeping and simple negligence were left in. That patient alone, as in a single patient case, all those findings of gross negligence would be sufficient to justify the imposition of the minimum term under the guidelines. So, but there's more. We have patient BA. Now, patient BA, some things were cut out. What was left in was what the appellate court cut out was the BA ER test, but they left in the findings of gross negligence with regard to the multiple EEGs. More seriously, they left in the lack of knowledge about the interactions of Depakote and Lamictal, and she was a minor. And she ended up having to go to the emergency room, and it was this lack of knowledge and prescription of this dangerous combination caused an adverse reaction to the patient. So that itself is gross negligence, a finding of gross negligence. Then we go to patient RC. This isn't just a one-patient case. This is a four-patient case. So we go to patient RC. And again, the Court of Appeal simply similarly upheld the worst allegations, again ordering the EEGs without medical indication, and most seriously, that the court found and upheld the finding that the respondent lacked the knowledge to read the EEG results. And EEGs are a very common tool for a neurologist. And they need to be able to correctly interpret this. And the Court of Appeal also agreed with the finding that because of this lack of knowledge, the respondent improperly diagnosed the patient with epileptic seizures based on her misreading and improperly diagnosed the patient with MS. So, and the court also found that the respondent contradicted herself when she claimed she did not diagnose the patient with MS. And the court agreed with the findings that the respondent made prior inconsistent statements to the board, stating that she did not, in fact, diagnose the respondent with RC with MS. My learned colleague is quite correct when he says that the hearing judge found made all the findings of credibility against the respondent. That is correct. But what is also more important, the Court of Appeal upheld all of those findings of credibility against the respondent. So that's not an issue anymore. The Court of Appeal has spoken. They found the ALJ's determination to be accurate. And then we have one more patient, DK. Now, while the Court of Appeal did strike the finding of the lack of a cures report, the Court of Appeal upheld all of the other repeated negligent acts that included failing to keep adequate records regarding her diagnosis, that patient DK had a tremor, and billing for services not substantiated by the treatment of records. And the court also found that she diagnosed patient DK with a tremor despite nothing to support the diagnosis. Again, this is a common theme with all her patients. All of these would call for simply the reinstatement of the court's original discipline in this case. Now, the fact that the respondent has completed some of the terms and conditions of her probation is to her credit, but those are requirements. That's not a benefit. She doesn't get a parade for that. She was supposed to do that. and anything that she has completed, the probation department will appropriately determine in her compliance with her terms and conditions of probation. Now, in the interest of justice, because the Court of Appeal did strike some of the allegations, but leaving in the majority and the majority of the most serious of the findings, the people are prepared, or rather the board, on behalf of the board, we are prepared to recommend that the board lower the term of probation by 6 months to 4 years and 6 months, to lower it to that level. But while the respondent is to be commended for her compliance with the probation and certainly for whatever she has done to improve her practice in the intervening time, public safety requires that she continue to be so monitored because these instances, these findings of gross negligence that the Court of Appeal upheld are too serious to let go. And whatever Dr. Yassa has done in the intervening time is fine. I mean, she could have won the Nobel Prize last year, but that is irrelevant and not relevant to our determination here today and to our case today. The court the court's record is what it is. The board is limited to the facts of the original case and whatever mitigation could be presented to the original at the original time, and that's by the board's own order and a Supreme Court decision that the board is essentially referencing. So, with that in mind, we look at the fact that the Court of Appeal sustained the most serious of the findings against Dr. Yassa. With regard to the first patient, they sustained all of them. With regard to the second patient, BA, they sustained ordering EKGs without medical indication. What was cut out was the BAER, not the EEGs. And they lack of knowledge about the interactions of the powerful antipsychotic drugs Depakote and Lamictal. Well, with RC, they similarly upheld the worst allegations that she again ordered EEGs without medical indication and that she lacked the knowledge to read these EEG results and improperly diagnosed the patient with epileptic seizures based on her readings of that and improperly diagnosed her with MS. Now, and they found for credibility, they did not find Dr. Yassa's testimony to be credible. They found inconsistencies and contradictions that the appellate court upheld. And in the case of patient DK, the court upheld the findings of repeated negligent acts with the sole exception of removing the issue of failure to consult cures. You have to do it now. You didn't need to do it then. So that's all. And so given all of that, the medical board could easily and properly go back to the guidelines, and the guidelines call for exactly what was imposed. That would be the minimum for the guidelines. And so we as the Attorney General's office as a suggestion in the interest of justice is suggesting that the board remove or lower the probationary period by 6 months, down to 4 years and 6 months, but reimpose all of the previously imposed terms and conditions, giving the respondent, of course, appropriate credit for those she has completed. And if she's got other things that she would like the board to consider as satisfying some of these requirements, that's at the discretion of the board through its probation department. They may or may not, and that's with the discretion that the board has granted its own probation department. So with that, I will thank the board and we'll sit down.
Thank you, Mr. Muni. Mr. Zimmerman, you have 5 minutes.
So let me respond to some of the comments, because I think some of those are not misleading by my colleague, but deserve some further explanation. There was a comment to the effect of the remaining findings of extreme departure are too serious to let go. Let me point out that the findings that remained after the Court of Appeals decision, the findings with regard to departure, none of those involved harm to the patient. None of those involved harm to the patient. There was a comment to the effect of she was not competent in reading EEGs, and there's a comment, EEGs are commonly used by neurologists. Well, that's true, but the fact of the matter is, in this case, the finding was based upon the patient's had a diary indicating that she had walked by a microwave at her house while she was undergoing an EEG test. Dr. Yassa questioned the effect of the microwave, and that was the basis of the finding that she was misinterpreting EEGs. It's not some general comment that she is incompetent. It was specific with regard to the EEG and microwave incident. I need to indicate to you that her compliance has involved record-keeping courses, and she has a practice monitor who is watching her record keeping. And she now understands more so than ever the importance of accurate record keeping. And I would suggest that the record keeping with these patients in and of itself led to many of the criticisms and many of the findings. I think that there was misinterpretation of her record keeping, but she now understands clearly the import of record keeping. And going forward, I am certain, and I can represent to this board that her record keeping is now detailed and accurate, and all of that lends itself to an assertion that recurrence of these various problems will not occur. And in terms of public safety, Dr. Yassa has dedicated herself to her proper patient care, and her compliance, I think, is important to consideration by this board. The AG's office has recommended a 6-month reduction in the 5-year probation. I think that the actions of the Court of Appeal and Dr. Yassa's compliance, actually over and above compliance, let me reiterate, she's
Mr.
had,
Zimmerman,
yes,
you have 1 minute.
thank you. Let me just reiterate that she's required to undergo 25 CME units every other year. In the past 3 years, she's undergone 1,000 CME credits. She's dedicated to further education and proper documentation. And all things considered, we would hope that the board would see it appropriate to conclude her probation at this point in time recognizing the 3 years and 3 months that she has already been through. So with that, I'll conclude my comments. Thank you very much.
Thank you, Mr. Zimmerman. Mr. Muni, you have 5 minutes.
Thank you, Your Honor. I respectfully disagree with my colleague's statement that there was not, in fact, patient harm. But patient harm is not required in these situations. In the situation, we are here to prevent patient harm, and patient harm is not a determinant factor in whether there is or is not gross negligence. You don't have to. It's the conduct of the doctor, not the outcome that happens. But parenthetically, with patient BA, we do have a situation in which the lack of medical knowledge of the interactions of Depakote and Lamictal caused an adverse reaction. I think we do have some patient harm. While I applaud the respondents' performance on probation, and certainly accept my colleague's representations of the improvement to her practice, which I think are commendable. Nonetheless, that doesn't really change where we are today. We are looking at the imposition of discipline based on the case that the board had before it at the time of its original order, subtracting minus those parts of the decision that were excised by the Court of Appeal. The Court of Appeal left standing for all of patient VA, who by itself would support the guidelines, the minimum disciplinary guidelines that were by the board's own 2016 guidelines that were imposed. Dr. Yassa received, I think, a level of discipline that was very reasonable and even lenient on the original disciplinary order. And she has been apparently working to correct her deficiencies as a medical doctor. But I don't think we should remove the probationary period completely in order to continue to monitor her, because the problems that caused it in the first place were sufficiently serious, and the problems that were left in by the Court of Appeal are still sufficiently serious. The gross negligence that was left in is sufficiently serious to warrant the continued monitoring on probation. We're recommending that 6 months be taken off the probationary period in recognition both of what she's been doing and in recognition of what the Court of Appeal removed. But we respectfully request the board to maintain the remaining terms and conditions and the period of probation minus that 6 months. And with that, I will submit it. Thank you, ma'am.
Thank you, Mr. Muni. Did Dr. Yassa want to address the panel?
Yes.
Yes, I'm going to change seats.
Okay. Good morning, Dr. Yassa. Raise your right hand, please. Do you solemnly swear or affirm under penalty of perjury that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Look to the camera on the right. Yes. Yes.
Dr. Yassa, you have 5 minutes.
Thank you for allowing me to say a few words here. I would like to add that I have 7 years of training in neurology, and I graduated in 1995. My certificate was 104,000, and between alive and dead, retired and practicing, and then I topped that in 2013 with being board certified in sleep medicine. The board certified physician, although allowed to testify by law, does not qualify in the medical field to give an opinion about a child neurology and or sleep medicine because it did not exist when he was there. The main problem between what he said and what we said was the MRI findings. The preponderance of evidence supports that myself, the neuroradiologist, and Dr. Cassini all agreed on the reading of the neuroradiologist. The only one who contradicted the neuroradiologist without seeing the MRIs and without having any expertise to testify about the MRIs was the board expert. In case of VA presented 1% of the population in the way her headache presented, and the treatment course for her improved with the medication I used, which was Depakote. And my diagnosis was based on the MRI finding, based on the neuroradiologist. There was disagreement between the court, so that I presented the literature which supports that this 1% of the population, which was presenting the arachnoid cyst as the neuroradiologist read it, presents with learning disability, which she had, and presents with seizures. And the seizures and the learning disabilities are tied together. So for me, I put 1.5 years out of my pocket, though the patient lost her insurance 3 months into the treatment, because I knew the importance of learning disability and seizures to protect the patient so that she can preserve her self-esteem. If the seizures are untreated, the patient is always ends up to be low achiever, low socioeconomic status, a burden on the family, burden on the society. I put 1.5 years out of my time and my dime to take care of this patient because I knew the seriousness and the importance of education in such an early age. The Court of Appeal said, "Oh, you didn't tell us enough about how is learning disability and seizures related." Well, the mom pursued learning disabilities caused by seizures after she left me, and she went into 2 subsequent neurologists who pursued the same thing. Yet the court found it extreme departure because I said seizures and breakthrough seizures. The mom told the neurosurgeon on 1/10/10 that the VA improved with using Depakote, improved in the headache resolved 4 months into the treatment, and the treatment mom tried 2.5 months before to treat her were over the counter. She was not responding. After I treated her 4 months later on the medication I put her, she improved, and the learning disability improved. The headache resolved, learning disability improved. I move on.
Yassa,
Yes.
you have 1 minute.
I move on to BA. There was no Lamictal added to the Depakote when when the board said there was, I failed to understand the Lamictal and Depakote. They were not added. As a matter of fact, Lamictal was added 1 month later. 1 month later, we corrected the board's decision 10 times, but they never learned. The difference between RC, I moved to RC. RC remains to have the same diagnosis from the subsequent neurologist. And I was found extreme departure to give her that diagnosis. She remains to have the same diagnosis from the every subsequent neurologist, whether VA, BA, or RC, and DK had the same plan. Whatever I recommended had the same plan after they left me.
Your time is up, Dr. Yassa. Thank
Your
you.
Honor, Dr. Yassa's entire statement relitigated the case and is challenging the findings that were upheld by the Court of Appeal. That is simply not allowed by law, and I would ask Your Honor to instruct the board to disregard those statements. They are outside the record, but they are an attempt to relitigate the record.
They're not outside the record. The fact that she's reiterating the record is her prerogative in her statement, and we are not here to relitigate, so the board can take the statements as her explanation, her further explanation, but not in an attempt to start the factual basis over. So I'll not strike the comments, but certainly the board understands that the limitations of the purpose for our being here today is to take the Supreme Court's direction and make a determination following that regarding the penalty. Dr. Yassa, thank you for your statements. We will turn to questions from the board. I will start with Dr. Thorpe. Dr. Thorpe, do you have any questions, either for Mr. Muni or Mr. Zimmerman or Dr. Yassa?
Thank you. Thank you, Judge Ron. So I do have a question for Mr. Zimmerman. The issue of, I mean, you don't mention the issue related to the young woman VA, where there was repeated normal EEGs, and a question of it's uncertain to me what Dr. Yassa's diagnosis was. Generally, seizures was part of her diagnosis, but all of these EEGs were negative, and according to what has just been said, all of the counts of extreme departures and simple departures were continued. Is that, do you have any statement, any explanation for that?
Yes, it's related to the disagreement between the physicians who were also involved in the care, having the patient referred for an MRI that was interpreted by a neuroradiologist as what's called an arachnoid cyst. And all of the experts at the hearing agreed that an arachnoid cyst may be the cause of seizures. So she's then referred by Dr. Yassa to a neurosurgeon at UC Davis, Dr. Bogans. Dr. Bogans said, I don't think this is an arachnoid cyst, but I'm concerned as to whether or not this lesion is in a closed or open space, because if it's in a closed space, it can cause pressure. And so what I recommend, Dr. Bogan says, is continued testing and a repeat MRI in 6 months, because we need to watch to see whether or not this expands or grows, etc. So it was our position that there was sufficient, indeed compelling reason for ongoing testing, whether it be MRI or EEG. Does that address your question? Not
Yes.
that well. Yeah, I'd be happy to try to clarify it. But there was ongoing issues about the exact diagnosis, and the experts, the neuroradiologist and the neurosurgeon, differed in their opinions. And that led to Dr. Yassa not wanting to simply dismiss the patient based on the neurosurgeon's findings. She continued to pursue and be wary of what may be happening with this young patient.
Thank you.
Anything further, Dr. Thorpe?
I have nothing further.
Okay, thank you. Ms. Campaverde, any questions?
I do not have a question. Thank you.
Thank you. Mr. Brooks?
I don't have any questions. Thank you.
Dr. Gonadev?
Thank you, Judge Roman. just see if it is actually appropriate. That's why I'll leave it up to you for Mr. Zimmerman. She's at a stage where she can apply, it looks like, for penalty relief with early termination of probation. Why not go through that process?
I think the,
I applied for the termination,
so she's applied for
and it's ongoing.
that process, and that's under submission at this point in time. Thank you.
Is that all, Dr. Gonadez?
Yeah, thank you, Judge.
Okay, thank you. Dr. Kraus?
No questions, thank you.
Thank you. Dr. Lawson?
Thank you for the promotion, but I'm not a doctor. In any event, I have no questions.
I saw the initials after your name and I didn't look as closely enough. Thank you. And at the beginning, I know Dr. Mahmood was not present. He's present now, correct?
Correct. Yes.
Okay, Dr. Mahmood, do you have any questions?
Yes, I do. So this is kind of a very intriguing case for me. The initial findings were changed by the Superior Court, and I understand that none of the patient harm issues were left there. And the management, is this something to consider if this statement to be taken correct, that the management plan stayed the same as Dr. Yassa was doing after that by several other specialists? If the management plan stayed the same, it can be confirmed, then we need to go back and think about this to cutting down the stuff. But other than that, I had the same question Dr. Ganaded already asked. Why not apply for early relief then for this thing? But these are the two concerns and questions I have.
Every single case with the same. Please let them know.
What was that first part for Mr. Zimmerman?
I'm sorry.
Dr. Mahmood, I'm not sure if that first part requires an answer or if you were more of a comment.
If it is appropriate to comment, then they can, our attorney can comment. If it is beyond the thing, because he already objected to the statement of Dr. Yassa, I don't know he would feel comfortable answering this question. If he feels comfortable, then I definitely would not know, will need to know the response.
If
Okay,
so,
If all four cases.
Mr. Zimmerman, go ahead.
if I understand the comment, in all of these patients, the treatment by the subsequent neurologist, the subsequent treating neurologist, had the same diagnosis and treatment as Dr. Yassa.
Okay, I see, Dr. Mahmood, and some of that was in the appellate court decision and somewhat addressed by the ALJ. So to the extent that we're talking about facts that were in evidence at the administrative hearing, yes, we can discuss those. And you're cutting out a little bit, Dr. Mahmood, so I'm sorry I didn't quite get all of that. But did you have Dr. Mahmood, did you have a follow-up? I'm sorry, Dr. Mahmood, was that all from you? I'm not sure if you're there and you know you're on mute.
Yeah, no, I partly heard you, but yes, we can discuss after that. Yes.
Okay, so you have no further questions?
No further questions.
Okay, thank you. Sorry about that. You're breaking up a little bit. So that's the end of the panel. I will open up generally. Does anyone, any member of the panel have additional questions before we close?
No.
Okay, hearing none, we will conclude here. Thank you all for your participation today. The matter is submitted. The record's closed. We're off the record.
Thank you, Judge
And before, I know that Dr. Thorpe, I know you need to address the open and close. Let me just real quick connect with the court reporter and then I'll turn it back to you. Ms.
I have
Luke, could I get the,
Sorry.
go ahead.
35, 35.
Okay.
And I have N.
1002?
Yes.
Okay, thank you. And I apologize for the message I got. I really don't know where that pop-up came from, so I'm sorry.
No
Sorry
worries.
about that. Okay, thanks for your help today.
Absolutely.
Dr. Thorpe, I'll turn it back to you.
Thank you. Thank you, Judge Ron. I appreciate your presiding here today and helping us through this process. It is a complicated process. We are now going to close the open session of the Panel B meeting and move into closed session. Those of you who are joining us on the closed session have been given a link to Panel B and the closed session, and we will terminate this link and see you on the next link. So we'll look forward to seeing you.
Dr. Thorpe, just a correction, we will be leaving this public meeting open. You guys will be going to the closed session. I'll be keeping this one open for the public. That was just to stay until adjournment.
Okay. All right. Well, thank you, Sean. We'll do it that way. Okay, we'll leave and then we'll come back to open after the end of the closed session. Welcome back to the open session of Panel B. Michelle, do we have any other business that we need to do other than entertain a motion for adjournment?
No, that's it.
Okay. A motion for adjournment would be entertained.
So moved.
Move to we be adjourned. We will adjourn Panel B for today, and we will see you at the medical board meeting at 2 o'clock.
Thank you.
Thank you.